Ms. Mellon. Mr. Cohen, good morning. You may proceed.
Good morning, Your Honor. Good morning, members of the Court. I represent the Premier Insurance Company in a series of cases that were consolidated for appeal. With regard to my part of the case, they involve three different claims. One involving Jeffrey Frank, a second involving Grazia Laferla, and a third involving Michelle Cote. Each of those individuals was involved in a motor vehicle accident in which they were struck by a municipally owned vehicle.
I take it, Mr. Cohen, that in each case the fund, the Massachusetts Insolvency Fund, declined to pay, correct, with respect to your three?
Yes, I believe that's the case.
I know it's not your client, but was that also true with respect to the case of Hanover?
No, I believe that...
So there was a payment and then a request for reimbursement?
Right, and
Attorney
Bruno will address that.
Right, okay.
Does the fund pay 100 cents on the dollar, or is it discounted in some way?
I believe that they would pay 100 cents on the dollar. In other words,
I mean, they act like any insurer if they're found responsible.
yes, they would act as any insurer would. In other words, they would have to pay the value of the claim. When you're talking about bodily injury claims, it's not as if there are liquidated damages per se.
I know. You have to have some calculation or settlement.
Right.
Your argument's pretty simple, isn't it? The policy says government vehicles are excluded. There's nothing in the two or three applicable statutes that say anything that would negate that policy provision. Therefore, uninsured, and you go to the fund.
Correct.
Or insolvent, because Legion went insolvent, so you go to the fund.
Because Legion went insolvent. I mean, I think that in an overall sense, what you see is that not every municipality in Massachusetts is obligated to obtain insurance.
But in this situation, where municipalities are involved, they would not get the benefit of the fund if they had purchased a policy through an insurer who became insolvent. Every other driver who obtained a policy from an insurer who subsequently became insolvent would have their claim covered by the fund. Is that right?
Yes.
But the municipalities would not.
That's correct.
That's if we accept your argument. Isn't that a perverse outcome? In other words, you want municipalities. There's an interest in having municipalities take out insurance policies.
I don't know that I would go so far, respectfully, to say that there's an interest, because the...
Why not? I mean, you don't want to have thousands of cars on the road where there's no insurance.
Well...
I mean, that's what insurance is all about. I mean, you might say if you're a business entity, well, you know, the municipalities can pay, but that's not a very well-run municipality.
Well,
but is there no insurance? If municipalities don't buy insurance, they're self-insurers. So I'm not sure that we can consider that they're not insured. They're just insured by a self-insurer.
They're in a sense, they're considered a variation on self-insured.
Well, that's only if they're self-insured.
Yes.
But once they buy insurance, they're insured.
Right.
Except that the statutory framework, if that's the proper terminology, exempts municipalities.
It exempts municipalities. I think if you look at the intention of the legislation and the background, it exempts. It says two things. One is you don't have to buy insurance, but it doesn't say if you buy insurance, you get penalized in any event.
No, but this isn't a matter of the municipality being penalized.
Certainly
yes, it is. They're paying for to underwrite the fund, aren't they? If they buy a policy, their dollars are going to underwrite the fund.
No, because I'm not sure that I'm following the thread of your argument. But I don't believe
where's the money to support the fund come from?
The money to support the fund comes from all the insurers who issue policies.
Including those who issue insurance policies to municipalities, correct?
That I'm not sure about. I don't believe so, but I mean, I'm not sure that that's really the...
Is it based on the number of policies, automobile insurance policies that a company writes? Is there subsidy based on the number of automobile policies they write?
No. There's a complicated formula that determines exactly how much each insurer is supposed to contribute to underwrite to underwrite the cost of operating the insolvency fund.
The commissioner approved the language in your policy. Did the commissioner not approve that language?
Right. The commissioner...
So the commissioner knew or should have known that this kind of situation might arise and the insolvency fund would be liable.
Well, that's really, and as somebody said earlier, that the argument that we're making is kind of simple. I mean, you really have to start with the language of the policy itself, and it's crystal clear.
Well, you think it's crystal clear, but let me just suggest to you that it is in a phrase which is dealing with legally self-insured. In other words, the legislature wanted to make sure that you are either legally self-insured, which if a municipality chooses not to have an insurance policy, you're legally self-insured. I mean, it seems to me that that's the context in which you consider an auto owned by a governmental unit.
Except that, again, respectfully, I believe that you're then almost, and I addressed this in my brief, you're almost starting to read language into the policy that isn't there. You're almost wanting for that to apply, it would almost be as if the policy was saying that, however, we do not consider an auto owned by a governmental unit unless it is covered or unless it is insured by an insurance company or someone who is legally self-insured to be an uninsured auto.
But if you back up to the first sentence or the two sentences before that, it says, sometimes the company insuring the auto responsible for an accident will deny coverage or become insolvent. So don't you have to read this in the context of companies insuring autos who become insolvent? And then we consider such an auto to be uninsured. You're still talking about insured automobile or automobiles that are insured by companies that go insolvent or that become insolvent. So in this case, there is a company that went insolvent, and the car that was insured should be, at least there's one way to read this, should have coverage that comes from the underinsured coverage.
Right, and again, I guess at the risk of repeating myself, but when you look at the overall framework of compulsory insurance in Massachusetts, you'll see that municipalities are exempt from the requirements of registration.
No, what you see is the following, I submit to you. You see there are three groups of people. There are people who are insured. You have to be insured, and then their company goes, belly up. People who are legally self-insured, because there is an opportunity for non-municipalities to be legally self-insured, and that's a very complicated, primarily financial assessment of whether it's worth your while to legally self-insure or create some entity that will legally self-insure you. And municipalities which automatically become legally self-insured, but they can opt out of that. If they opt out of that, which they've done here, these ones, then they become just irregular insured. Why would it not make sense to just treat them like everybody else who has an insurance policy?
Well, because municipalities are not the same as anyone else that has an insurance policy.
Sure they are.
Well, for one thing, again, in an overall sense, the liability against any municipality is capped at $100,000.
Is that true if they carry insurance?
Yes.
So in other words, they only carry that much insurance?
For auto, I won't profess to know exactly what each municipality that decides to carry insurance covers or takes as coverage, but I believe Chapter 258 specifies.
Aren't we focusing on the wrong party here? The people that held these policies were the people who were injured or had someone injured in the accident, were they not?
Correct.
And the exclusion is in their policies. It's
Correct.
not in the municipality's policies.
Correct, because
Therefore, why shouldn't it be enforceable against them and let the municipalities, the chips against the municipalities, fall where they do?
Well, and I believe that one of the trial court decisions, the one by Judge Donovan in Norfolk Superior Court, suggests that or actually suggests that the chips would fall where they would lie.
Well, that one's a little problematic, because didn't she say they first had to go against the town, and then if the town didn't pay or paid, that the town could go against the fund or something like that? It was a little tautological, as I recall,
Well, it's consistent with your point of view.
in a broad sense.
Right. But again, it's right. But it is.
Well, anyway.
Okay. Thank you, Mr.
Thank you.
Cohen. Mr. Bluner?
John Bruno, I represent the Hanover Insurance Company, and as far as the issues relating to the Mass Municipal Insolvency Fund, I do have a comment about those, but I'd like to start with the issue that's different, and that's in my case. We filed a complaint for declaratory judgment in answer to the Insurance Insolvency Fund. We're unique insofar as they made a payment and they're seeking back to subrogate. It's our position that Judge Van Gestel in the Superior Court, when he essentially dismissed our claim, did that incorrectly, that procedurally there was no device available.
Why do you think that his interpretation of the safety insurance company case is wrong?
I think his interpretation of the safety insurance company case deals, well, that gets back to the municipal liability. I think that what he dealt in that case is they were looking in the safety case, or the court was looking in the safety case at optional bodily injury stacking on one on top of the other. The emphasis in that case had to deal with the insured driver as opposed to an insured vehicle. This situation is entirely different. This situation is the claim, in our case, the claim of the estate of Furness as against Hanover Insurance Company, not the claim against the Insurance Insolvency Fund. So I think that the analysis that to be correct in the municipal, the governmental unit municipal issue, we have to look at what the Insurance Insolvency Fund is supposed to do. Under that statute, we're supposed to have an insured person exhaust any claim, and in this case, the estate of Furness didn't have a claim because they were trying to get an uninsured payment from their insurance company, and we say that clause in there that says that a government can't be an uninsured vehicle meant that they didn't have a claim at all. And to keep on with that point, the court mentioned this morning about the fact that there is insurance in this case, and precedent is firmly established, and I cited in the brief the Ayala case, A-Y-A-L-A, which specifies that just because you buy insurance, which is allowed under the the sovereign immunity statute, allows a municipality to buy insurance if they want to. But the Ayala case specifically says that because you buy insurance doesn't change whether or not your liabilities change. So I don't think the fact that insurance is purchased by, in my case, Braintree, makes any difference to the analysis of the policy. I think the analysis of this case has to be that we look at what the Insurers Insolvency Fund statute says. That says that the insured has to exhaust his claim. In my case, the estate of Furness had no claim because the policy quite clearly says governmental unit is excluded. And the governmental unit...
So you read that as saying the governmental unit is excluded regardless of whether the governmental unit happens to buy insurance or be a self-insurer?
Absolutely. Absolutely.
But, again, that makes no sense at all.
Makes no sense? I'm sorry.
No.
Well, the controlling statute is 175-113L.
Yes, and no policy shall be issued or delivered in the Commonwealth. Such coverage shall include an insured motor vehicle. I mean, yes.
Mm-hmm.
But 175D, Section 5, says that that the fund shall pay, quote, covered claims against the insolvent insurer.
Right.
There is a claim here against an insolvent insurer, isn't there?
In my case, the estate of Furness was going to sue the town of Braintree for a liability claim. The fund, I think, mistakenly paid that, and then they came back to Hanover.
But you've got time, don't worry, Mr. Bluner, but that would be true in any case, correct?
Yes.
In other words, sometimes there's a settlement, and you say, well, wait a minute, I don't think there was any liability. There was no, they paid, I don't know on what basis they paid, but at least as you laid out the facts, it didn't seem to me that there was liability, against the town.
But this squares, your position squares with the statute. There's nothing that in 113 that prohibits this.
That prohibits...
this interpretation.
Which interpretation? The funds?
The one yours.
Oh, mine, there's nothing, no. And to
And
answer...
furthermore, there's an exclusion in 175D1 sub 2 that covered claims shall not include any reinsurance, insurance pool, or underwriting insurance. And you're not any of those either. We're
not. To answer Justice Spinner's question, the claim by the state of Furness is a liability claim. They're suing, they should have sued Braintree, saying, Braintree, you were responsible. The claim in this case that we're dealing with is an uninsured claim against the estate's auto insurer. And I think those are two vastly different things.
But doesn't it depend upon, the underlying basis for the claim is a claim against the town of Braintree for which there is no longer insurance?
Well, the only way they come to us is because there is a provision in the Insurers Insolvency Fund statute that requires a claimant to exhaust any other insurance. That's how they come around to us. And we say that they don't have a claim here because of the governmental unit exclusion. So they're really two different things, although the analysis all kind of...
Approved by the commissioner.
Mr. Bruno, let me ask you this. Assuming that the liability issue is settled and there is liability against the municipality, so not your case, but another case, no question that the municipality is liable, and the municipality has obtained insurance, right, and the municipality, the insurer of the municipality is now insolvent, and the municipality therefore goes to the fund. On what conceivable basis can the fund refuse to pay?
They can't. The only conceivable basis is to require the claimant to exhaust any other insurance.
Well, there isn't any other insurance. Let's just say there isn't any other insurance.
In that case, then the fund would have to step into the shoes of Braintree and handle the liability claim.
And then it could or could not go against you.
The fund could not, I say.
Well, I know that, but has the legislature intended to essentially make the fund, the last resort for municipalities long before it would be the last resort for any non-municipalities? I mean, if you look at the legislative structure, it just doesn't make sense.
The fund is intended to be...
The fund is only liable because the municipality purchased insurance, correct?
That's correct.
And once it does that, isn't the municipality just in the same pool as everybody else?
No, because in this particular unusual circumstance, no. Because the fund statute requires the claimant, in this case the estate, to exhaust any other insurance that claimant may have. And the claimant doesn't have any other insurance because the insurance policy specifies that a governmental unit can never be, by definition, can never be an uninsured motorist.
Okay. Thank you, Mr. Bloom.
Thank you.
Ms. Vargas?
Thank you, Your Honor. May it please the Court, Christine Vargas for the Massachusetts Insurers Insolvency Fund, and with me, Mark Robbins. There are 3 points I'd like to cover today. First and foremost, Section 113L mandates uninsured motorist coverage where the responsible auto's insurer is declared insolvent. It requires this coverage.
But Ms. Vargas, under other provisions, though, aren't governmental units not required to have insurance policies?
Yes, Your Honor. However, when a government entity opts to purchase insurance, the fund is implicated, as is Section 113L. Now, when we look at the Fund Act and how that interacts with Section 113L, it's clear that the legislature intended that solvent insurers in these cases must be the first source of recovery.
Then why did the commissioner approve this exclusion?
The commissioner approved this exclusion as evidenced by the affidavit of Victor Finicos, which is on the record, because in instances where the government entity opts to not purchase insurance, the Hanovers and the Premiers of the world shouldn't be required to provide uninsured motorist coverage.
But is that affidavit valid evidence in any way? It seems to me the affidavit is worthless because either the insurance policy is approved or it's not approved by the commissioner, and that's the end of it. And what one employee says, I don't see how that affects the acceptance of the policy by the insurance commissioner.
Don't either. It's almost like the affidavit saying, gee, I wish we didn't do this because now we're going to get hung out.
I think what the affidavit says is, here's the reason why we did this. Here's the interpretation of this language.
But that's meaningless. The policy has been promulgated, and it says what it says.
In effect for years.
Yeah, isn't the question here really whether or not the policy is void because it's trumped by the statute?
Certainly, Your Honor.
What statutory provision trumps the policy?
Section 113L, which mandates uninsured motorist coverage and makes no exclusion whatsoever for government-owned vehicles. And if the mass standard auto policy can't be interpreted to mean, what we're talking about here is government-owned vehicles that never purchased insurance. If it can't be interpreted to mean that, then it has to be invalidated, and there's ample precedent to support that in Massachusetts.
Do the city's policies, when the city buys a motor vehicle insurance policy, do those policies have uninsured motor vehicle coverage? Is that an option?
Well, I'm not entirely sure, Your Honor. The government entity purchases a policy.
Well, can I ask you this? Let's assume the insurance company, Premier or Hanover, pays, in this case, under its uninsured motorist coverage. I take it then they would have an action against the city, would they not?
If the insurers pay the uninsured motorist benefits for offset against the city?
Sure.
Yeah, then they'd have an action against the city.
They'd subrogate.
Right.
And
So
sue the
the
city.
Premier pays under its policy, uninsured motorist. It pays, as you're suggesting, they must. Then the insurer would have an action against the city to recover that, a subrogated action, right?
I suppose it's possible.
And then the city would go turn to the fund to collect from the fund because its insurer had become insolvent, right?
I'm not sure I follow, Your Honor.
Well, the city has insurance, and the city's insurer has become insolvent.
Mm-hmm.
So if the city was hit with a judgment, wouldn't the city then be able to recover from the, maybe I'm wrong.
Well, the city would never have been hit with the judgment because the city would have sent the letter over to its insurer and said, defend. And like everybody else, that under 113L has an insurance policy, and they come back and say, see bankruptcy court,
Right.
send it down there, and they just take it and send it over to the fund.
Well, no, because the Fund Act excludes insurer claims. The Fund Act states that the fund cannot pay for the benefit of an insurer. So those claims that were submitted by insurers in the hypothetical that Justice Cordy posed, if the fund paid, it would benefit an insurer, and that contravenes the Fund Act.
Well, may I ask you this? You say when a government entity opts to purchase insurance, then the fund is implicated. Why should a government entity ever opt to purchase insurance?
In order to protect
itself.
To protect itself,
And
certainly.
here,
As they did here, as several of them
As
did
they did
here.
here.
Sure,
yes.
the cost of purchasing insurance could be quite a bit. I mean,
well, it depends on the
take
size.
the city of Boston, which has thousands of vehicles. The premiums could be prohibitive. Self-insurance might
That
be the
could be
better
the
way to
case,
do
though,
it.
yes.
Or they could insure part of the, the police vehicles and not insure the highway vehicles. They got all kinds of options.
Well, that's what the legislature said, that municipalities can look and do the same financial analysis that anybody else does, and if it's in their interest to self-insure. It seems to me, and I go back to it, that the result that the Premier and Hanover are looking today is a sort of perverse incentive for cities and towns not to, even if the analysis is makes it clear that self-insurance is not in their best interest, not to insure, because we know that a fair number of insurance companies have declared bankruptcy. That's why we have the fund. and they don't get the protection. And I see absolutely nothing that says that that's what the legislature intended. And I think, at least from my reading of it, 113L makes clear, once you're in there, you have to have that.
Couldn't agree more, Your Honor.
Well, what is it in any statute that precludes this kind of an exclusion, which logically seems to make sense?
113L.
The 113L doesn't preclude it.
But it doesn't preclude
It's
it.
silent on it.
But 113L defines uninsured motor vehicle to include any vehicle that is left uninsured because its insurer was declared insolvent.
But the problem is the policy language says that a city or town is not there is no insolvency situation with a motor vehicle. Or with a motor vehicle owned by a city or town. I'm wondering whether 175D, Section 5, solves some of the problem, because where it says covered claims against the insolvent insurer have to be paid by the fund. I don't know.
Ms. Vargas, could you address Judge Van Gestel's second argument? In other words, once he got through the first part, and his reliance on the safety insurance company.
I think Judge Van Gestel reaches the same destination that we do. He just takes a different route, and he.
I understand that, but I'm asking you to tell me whether or not you think that's an appropriate way to go.
Well, yes, Your Honor. Judge Van Gestel is simply saying the relevant inquiry here is whether the motor vehicle itself is uninsured, and the status of the owner as insured or uninsured isn't relevant, and that Judge Van Gestel just chose to rely on the safety decision to reach that conclusion.
Stated differently, do you agree that his interpretation of safety insurance is correct?
Yes, Your Honor. The inquiry is the motor vehicle insured or is it not? And if it's the motor vehicle that is uninsured, then Section 113L and the Fund Act apply.
Can we clear up the procedural problem with Hanover? Would you agree that their claim should not have been dismissed?
Well, that issue wasn't properly before the court. The parties agreed.
Well, of course it wasn't before the court, because they were dealing with a summary judgment in which Hanover was not included. So how can his claim be dismissed, or its claim?
It hasn't been dismissed, has it?
No, it hasn't been dismissed.
It's still there.
It's what Judge Van Gestel said in his decision was, we're not going to expend the court's resources unnecessarily at this point in deciding the Hanover counterclaim. The parties can work that out amongst themselves. This can be decided on remand. The parties agreed to consolidate these cases for the limited purpose of addressing the mass standard auto policy language in the context of the legislative insurance scheme in Massachusetts. So the Hanover counterclaim was not.
You've actually said to the court that if the Superior Court's ruling in Hanover, I believe, is affirmed, right?
Premier.
Yes.
Which is the 5251 case? Who's that?
5251 is.
That
Premier.
Premier?
Yes, Premier. And what we sought, the ruling that we sought from the court is a declaration that the exhaustion and offset requirement applies, so that if the fund pays monies to the claimants, that it should be in an amount that's offset by the recovery from the solvent insurers.
Well, essentially, as I understand what you've told me on your footnote, is that if we affirm Judge Van Gestel, then Hanover goes back, and if we reverse, then to say that coverage exists, Hanover's counterclaim will become moot, correct?
Yes, because.
Because they're going to pay.
Exactly.
So, I mean, it seems a little odd because it says separate and final judgment, but one could read that to say it's a separate and final judgment with respect to the summary judgment questions of coverage.
Exactly, Your Honor.
Okay.
Yes. Now, I know that this Court is familiar with the fund and has issued several decisions regarding it, but it might be useful here to cover a few more of the aspects of the fund that are germane to these cases. The fund is a non-for-profit entity created to provide limited protection for claims to insureds in the Commonwealth when their insurers are declared insolvent.
Do the premiums that the cities and towns pay to buy motor vehicle insurance in any way go into either directly or indirectly as a result of some calculation the subsidy that the insurance companies pay to support the fund?
Absolutely, Your Honor.
How does it work?
The member insurers in Massachusetts are assessed fees that they in turn pass on to the public in the form of higher premiums. So the member insurers pay into the fund, including...
Well, that's kind of a wash, isn't it? I mean, Legion paid into the fund until it went insolvent.
Yes.
Hanover and Premier pay into the fund. So what difference does that make?
But is it based in any way upon policies that are written for cities and towns?
No, if you look at Section 5, it makes no separate, 175D Section 5 makes no separate, you don't either exclude or double premium or do anything else, correct? It's
That's
just every
correct, Your
insurer.
Honor. Yes.
So if a company, if a small company that's only insuring, let's say, 500 cars, how is their contribution to the support of the fund different from a company that's underwriting policies for 50,000 cars?
It's only different in that they would pay a smaller amount because the fees assessed are based on a percentage of the premium. So, I mean, they don't
So it is based. There is some calculation that depends upon the policies that are written.
There is some calculation that depends upon the premiums that are charged to the insured. So, yes, if an insurance company, I believe it's something in the neighborhood of 2%, if an insurance company charges its insured premiums, they pay 2% of those premiums.
Well, they can't be assessed more than 2%.
That's
so
correct.
no doubt
That's
they
the
get
cap.
assessed
That's
2%.
the cap. Yes,
Know
Your
anything
Honor.
about Legion? Did Legion, maybe you don't know this, did Legion specialize in insuring municipalities? Or do we know that?
I'm not entirely certain,
never
but
heard that name
believe
before.
that they insured a lot of
I
municipalities.
imagine the exclusion that's in Premier and Hanover's policy is in everybody else's policy, too. Liberty and Amica, all the other folks, Arbella, right?
Pardon?
The exclusion we're talking about is in every other policy, isn't it?
Yes, the Massachusetts auto policy is standard throughout. And we submit that if this language can't be interpreted to mean we don't consider vehicles that are owned by a government entity to be uninsured only in the case where they didn't purchase insurance in the first place. If it can't be interpreted to mean
So
that,
if we
then
rule
it has
in your
to be.
favor, all our premiums go up.
No, Your Honor. How so?
No? Well,
No, in fact, quite the contrary.
these companies are going to be liable
These companies are liable to.
as primary insurers at that point? The fund isn't liable?
The fund is liable in an amount that is offset by what the insurers pay their insureds for uninsured motorist coverage.
Can I come back to this question? You said that the fund pays claims to insureds when their insurers are insolvent.
Yes, Your Honor.
So I'm an insured, and I'm in an accident, it's my fault, I get sued. My insurer is insolvent. All right? So I get hit with a $300,000 judgment. What do?
Your insurer is insolvent.
My insurer is insolvent. I've been sued. I now have a judgment against me. Can I turn to the fund?
Let's see.
I'm an insured.
Yes.
I get sued for something covered by my policy. I get hit with a judgment. My insurer is insolvent. Can I turn to the fund?
Yes, Your Honor.
Well, then why can't the municipality turn to the fund if Premier sues the municipality?
Absolutely.
Because
Because the municipality's insurer is insolvent, isn't it?
I'm afraid I don't follow, Your Honor. If the municipality's insurer is
Is
insolvent.
insolvent, and they get sued, and there's a claim against them, and, I mean, they get a judgment against them, why can't they turn to the fund?
Because first you're required to exhaust coverage that is solvent.
Okay. I don't understand who's required. Me, the municipalities? What other am I supposed to exhaust here? I'm insured by Legion. I get sued. I lose. Legion's insolvent. Where else am I supposed to turn?
After any insolvent coverage has been exhausted, then then the resort is to the fund, but the fund is a source of last resort. And what the Fund Act does is, first you turn to any source of solvent coverage, and then the fund can step in and pay covered claims.
I understand that, but if Premier pays this claim and sues me, I'm the insured, my insurer's insolvent, I have no other recourse to insurance. Don't I turn to the fund?
The fund can't pay for the benefit of another insurer, so in that...
They're paying for the benefit of me. I've been sued. I held the judgment.
But if Premier has paid, the fund can't then make a payment that's going to benefit Premier.
Going to benefit me. I'm the one who has the judgment against me.
But it would ultimately benefit Premier.
So I'm out. So in other words, I'm an insured. My insurer's gone insolvent. I lost my coverage, and the fund doesn't pay anything to me.
Well, the insured is protected by the offset, and that's the limit of it. Any offset against the fund's liability, which would be whatever the solvent coverage is offset by what the fund can pay, and that's the protection that the Fund Act provides to insureds.
Okay.
And that's
Okay.
the limit of it.
Thank you, Ms. Vargas.
Thank you, Your Honor.